If you think a Supreme Court 9-0 ruling just banned guns in all 50 states, let me be clear with you right now. That did not happen. That claim is false. No Supreme Court decision, no federal court ruling, no combination of rulings has banned firearms in all 50 states. The videos making this claim, and there are multiple versions of them using nearly identical titles, are designed to generate clicks and fear, not to accurately inform you of the law. And the reason I am leading with that statement directly is that a licensed Florida board-certified criminal trial attorney named W.F. Casey Ebsary Jr. specifically addressed this pattern of videos in a public warning in March 2026. He said these viral gun ruling claims are fake or at best dangerously misleading, and that acting on them can get you arrested, charged, and convicted. He is right. The law does not change because a YouTube title says it did. And if you make legal decisions based on videos that describe rulings that do not exist, the consequences fall entirely on you. Now let me tell you what is actually real. Because here is the important thing. There is a genuine, real 9-0 Supreme Court decision about gun rights that came down on June 18, 2026. It is called United States v. Hemani, case number 2-4-1234. It does apply in all 50 states because it is a federal constitutional ruling. It is genuinely important, and it is one of the most significant gun rights expansions in recent history. But it did the exact opposite of what the viral title claims. This 9-0 ruling did not ban guns. It expanded the constitutional protection for a significant category of gun owners. So, subscribe right now and let me tell you what the Hemani decision actually says, why it matters, and how to understand it accurately in the context of everything else that has changed in gun law in 2026. The Hemani case started with Ali Hemani, a Texas man who told FBI agents during a search of his home that he used marijuana about every other day. The agents found a firearm. He was charged under 18 United States Code Section 922 G3, the federal law that makes it a crime for an unlawful user of a controlled substance to possess a firearm. The penalty is up to 15 years in federal prison. The government never claimed Hemani was dangerous, never claimed he was armed while intoxicated, never claimed he was addicted, just that he used marijuana with some regularity and owned a gun. The Supreme Court said in a 9-0 decision that prosecuting someone on those facts alone violates the Second Amendment. Justice Gorsuch wrote for the majority. He applied the Bruin historical tradition test. He asked whether the government could point to a historical analog, a law from the founding era that is relevantly similar to the modern drug user gun ban applied to an occasional marijuana user with no showing of danger. The government tried. It pointed to historical laws about habitual drunkards, people who drank to such excess that they were practically incapacitated and could not manage their own affairs. The court rejected that analogy on every relevant dimension. The historical habitual drunkard was practically incapacitated. Hemani was not alleged to be. The historical laws targeted demonstrably dangerous individuals based on individualized findings. The modern law automatically banned anyone who used any controlled substance with any regularity regardless of actual danger. The historical laws worked through legal proceedings. The modern law was entirely automatic, with no hearing, no finding, and no individualized assessment of any kind. The result: prosecuting Hemani under 922 G3, based solely on marijuana use with no evidence of actual danger, was unconstitutional. A 9-0 vote. If you are finding this important, subscribe right now, because I am about to explain exactly what this ruling means for you and what it does not mean, and both parts of that answer are critical. Now let me tell you what Hemani is and what it is not, because the gap between the two is where people get into trouble. Hemani is an as-applied challenge. Hemani challenged not whether 922 G3 is always unconstitutional in every case, but whether it was constitutional as applied to him, given the specific facts of his situation. The Supreme Court agreed with that narrow framing. The statute, 18 U.S.C. 922 G3, is still on the books. The DOJ can still prosecute people under it. What Hemani establishes is that the government must show more than regular marijuana use. It must show something that connects the drug use to actual demonstrated danger, something analogous to the historical habitual drunkard who was practically incapacitated. What exactly that additional showing must be has not been fully defined. That question will be worked out in future cases as courts apply Hemani. The lower courts will have to work through factual questions case by case. Is addiction enough? Is being high while carrying a weapon enough? Is a pattern of violent behavior combined with drug use enough? Hemani answered the question for the most minimal case. Regular marijuana use alone with no evidence of danger is not enough. What more is needed will be determined over time. Here's the specific practical impact. If you use marijuana occasionally and you own firearms and you have never been shown to be dangerous, your constitutional position is significantly stronger after Hemani than it was before. If you have been charged under 922 G3, based solely on marijuana use without any showing of actual danger, Hemani is a powerful argument in your favor, and you should contact a criminal defense attorney immediately. If you have previously been convicted under 922 G3 for marijuana use alone without any evidence of danger being presented at trial, Hemani may give you grounds to challenge that conviction through post-conviction proceedings. Consult an attorney. But here is what Hemani does not do. It does not change the ATF background check form, Form 4473. Question 21E still asks whether you are an unlawful user of or addicted to any controlled substance. If you answer truthfully that you use marijuana, you are disqualified from purchasing a firearm from a licensed dealer. If you answer falsely, you commit a separate federal crime of making a false statement on a federal firearms transaction form. Hemani is about prosecution for possession based on drug use. It is not about the purchase process or the Form 4473 question. Those remain unchanged. Hemani also does not change state gun laws. Every state's gun laws remain exactly as they were before June 18th. Hemani narrowed the federal government's prosecution authority under one specific federal statute. It did not touch anything at the state level. States that restrict firearms in various ways are not affected by Hemani's reasoning. States that allow broad gun rights are not affected either. State laws are what they are. Hey, 73% of people watching right now are not subscribed. I just explained the most important 9-0 gun decision of 2026, and the viral version of it said the exact opposite of what actually happened. Subscribe right now so you get the accurate story every time. Now let me use this as an opportunity to explain something broader, because it will help you evaluate every viral gun ruling claim you see going forward. When you see a title saying a court ruling banned guns in all 50 states, there are two questions you should ask immediately. First, which specific court issued this ruling, and what is the case name? If the video cannot give you a case name, a case number, a citation, a court name, and a decision date, the ruling does not exist. Legitimate Supreme Court decisions are public documents. They have case names. They have docket numbers. They are published on the Supreme Court's official website. If someone claims a unanimous decision just changed gun laws nationwide but cannot tell you what case they are talking about, they are making it up. Second question. Does the ruling actually say what the title claims? The word banned in a headline is doing enormous work. Most gun-related rulings do not ban anything. Most expand rights, narrow a prosecution standard, or apply a constitutional test to a specific statute. The distance between what a ruling actually says and what a viral title claims it says can be enormous. The Hemani decision is a perfect example. 9 justices unanimously ruled on a gun case. The ruling applies in all 50 states because it is a federal constitutional ruling, but it expanded rights, not restricted them. A viral title could truthfully say, Supreme Court 9-0, ruling changes gun law in all 50 states, and it would mean the opposite of what the alarming framing suggests. Let me now put Hemani in the context of all the real gun rights developments that have happened in the first half of 2026, because the full picture is actually remarkable for gun rights advocates. On January 3, 2026, the Ninth Circuit struck down California's urban open carry ban in Baird versus Bonta. That decision restored the right to openly carry firearms in the counties where 95% of California's population lives. On June 18, 2026, the Supreme Court's 9-0 Hemani ruling limited the government's ability to prosecute marijuana users for firearm possession without showing actual danger. On June 25, 2026, the Supreme Court's 6-3 Wolford versus Lopez ruling struck down the vampire rule in Hawaii, California, Maryland, New York, and New Jersey, restoring the right to carry on private property open to the public without needing the property owner's permission. And on June 29, 2026, The Supreme Court's 6-3 Trump versus Slaughter ruling gave the president sweeping new authority over independent federal agencies by overruling Humphrey's executor. This is the real picture of gun law in 2026. It is not a picture of guns being banned in all 50 states. It is a picture of gun rights being expanded in multiple directions simultaneously. The open carry rights restored in California, the marijuana user prosecution rights narrowed by Hemani, the public carry rights expanded by Woolford, the legal battles over assault weapons bans continuing with the Seventh Circuit's pending PICA ruling, the federal S.65 and H.R. 38 reciprocity legislation pending in Congress, the Virginia assault weapons ban taking effect July 1st while being challenged in multiple courts, the constitutional carry trend now covering 29 states. None of this resembles a picture of guns being banned in all 50 states. But I want to address the reason these viral ban claims spread so effectively. And it is not stupidity on the part of the people who share them. It is that gun owners are genuinely worried. The regulatory and legislative pressure on gun rights is real. In 2025, 33 states passed 89 gun safety bills by the count of pro-gun control organizations. Virginia just enacted an assault weapons ban. Several states have expanded red flag laws. The ATF has gone through significant regulatory changes in recent years. The concern that government is moving against gun rights is legitimate. That concern creates an audience receptive to alarming headlines. But the alarm has to be based on accurate information to be useful. Fear based on fabricated court rulings does not protect gun rights. Accurate understanding of real legal developments is what actually helps gun owners navigate their rights. Let me give you a specific framework for how to evaluate gun law claims going forward. Rule 1. Demand case names and citations. Every real Supreme Court ruling has a name, a case number, and a date. Ask for all three. Rule 2. Read the actual holding, not the headline framing. The holding of Hemani is that the government cannot prosecute a marijuana user without showing actual danger. That is very different from guns banned in all 50 states. Rule 3. Understand the difference between federal and state law. A federal ruling applies in all 50 states, but it governs federal prosecutions, not state laws. State gun laws require state legislative or state judicial action to change. A federal court ruling does not change what California, New York, or Texas law says about firearms. Rule 4. Distinguish between rulings that expand rights and rulings that restrict them. In 2026, the major gun rulings have overwhelmingly expanded rights, not restricted them. Hemani expanded protection. Woolford expanded carry rights. Baird expanded open carry. The pattern is not consistent with the narrative of guns being banned. Rule 5. Look at who is actually affected by a ruling and how. The group most immediately affected by Hemani is marijuana users who also own firearms. If you do not use marijuana and you are not under a firearm disability, Hemani has no direct immediate effect on your situation. The group most immediately affected by Woolford is concealed carry permit holders in Hawaii, California, Maryland, New York, and New Jersey. If you are in a different state, Woolford changes the legal principle but has no immediate practical effect on where you can carry. Understanding who a ruling affects allows you to assess how much you personally need to worry about it. Your action plan coming out of this video is straightforward. First, when you see a viral gun ruling video, ask for the case name and citation before sharing or acting on it. Second, if you use marijuana and own firearms, understand Hemani accurately as a partial protection against prosecution, not a blanket immunity. Consult an attorney about your specific situation. Third, if you are in one of the 5 states where the vampire rule was just struck down by Woolford, understand the new carry default has changed, but private property owners can still exclude. Fourth, follow reliable sources for gun law updates. Case names, citations, actual holdings, not viral titles. And fifth, support the organizations that are litigating these cases. FPC, SAF, NRA, GOA, NSSF. They need resources to keep winning cases that actually expand your rights in real ways. The picture of American gun law in June 2026 is not one of firearms being banned in all 50 states. It is one of significant legal battles being fought simultaneously on multiple fronts, with gun rights advocates winning many of them, while facing real challenges in others. The Supreme Court has been expanding Second Amendment protections consistently since Bruin. The constitutional carry movement covers more than half the country. The most recent Supreme Court gun decision was a unanimous ruling in favor of a gun owner's rights. None of that sounds like all 50 states banning guns. Know the real law. Reject the fabricated version. And subscribe right now because I will keep covering the real developments with the real case names, the real citations, and the real analysis. This is educational content only, not legal advice. For your specific legal situation, always consult a qualified attorney.